Welcome to this edition of 10-Minute Takes from Brodie's. My name's Fiona Scott and I'm a Senior Associate in our Land and Rural Business team.
I'm Kate Donachie, a Managing Associate in our Health and Safety team.
Today we're going to talk about health and safety duties and what that means on a practical level to businesses operating in the rural sector. Kate, I think health and safety is something which can feel difficult to navigate. Do different duties apply in the rural sector than, for example, in construction?
Yes, it can be difficult to understand how these duties apply in the rural environment, but the same overarching duties apply whether you're working on a building site, in a school, or on the land. And those duties are found in the Health and Safety at Work Act 1974. That act requires all employers, so far as is reasonably practicable, to ensure the health and safety of employees, other workers, and members of the public who may be affected by the employer's operations.
Okay, so in principle, the same duty applies no matter what the line of business. And then I would usually think of health and safety obligations as being something owed by an employer to an employee. But given what you've said there, it's wider than that.
Yeah, that's right. It is important to understand that the duty doesn't just apply to employees or people who are formally employed. It will apply to self-employed people and any independent contractors you have on your land and who might be affected by the work that you're carrying on there.
Okay, and just thinking about that, actually, lots of people in the agricultural sector in particular will be working in family farms. There might not be any kind of formal employees or any other people out with the family as such. Will HSE still be interested there?
Yes, absolutely. They will be. Anyone who's self-employed in the agricultural sector is automatically subject to health and safety duties. And a self-employed person there has a duty to take care for the same people we've just discussed. And again, so far as is reasonably practicable.
Okay, so the duties to ensure the health and safety of all those people so far as is reasonably practical, that's really wide, and then also pretty vague.
Yes, it is. There are regulations which sit under the Act which create specific obligations for particular kinds of work. For example, the PPE regulations, the work at height regulations, and the lifting operations and lifting equipment regulations. Those regulations provide much more detail and set out properly what's required.
Okay. And again, do all of those regulations apply equally across all sectors? Are there any exceptions, or for smaller businesses, for example?
Well, in general, the regulations do apply across all sectors and all business sizes. There are some exceptions, but the basic point is the obligation to ensure health and safety so far as is reasonably practicable. And I think it might be worth a word at this point on what reasonably practicable means. It's a slightly odd phrase. It's really quite a high standard. It doesn't mean the same as physically possible, but the HSE will not take into account a business's ability to pay for something. It's a level playing field in that regard, and so the same duties will apply to an international business as a small family business, only operating on a very small scale. If you wanted to show that it wasn't reasonably practicable to do something, you would have to show that it involved a grossly disproportionate sacrifice to achieve. An example of that might be a very expensive piece of machinery and a new way of working to remove a very low risk of minor injury. And where the risk of injury is greater, it's more likely to happen, or the injury that would occur is more serious. It gets more difficult to show that a sacrifice was grossly disproportionate.
Okay, that's useful to understand. And so then what are the consequences if a business doesn't comply with the regulations?
Well, breach of the regulations can result in a criminal prosecution, and in a very worst case scenario, this could involve someone being sentenced to a jail term of up to 2 years or a fine, which will be a significant proportion of the business's annual turnover.
Gosh, and we often hear in the press about people suing employers for damages when they're injured at work. Does that apply here as well?
Yeah, that is another possibility. So if someone's injured, they can sue a business for financial compensation, damages. Breaching the regulations doesn't give someone an automatic right to compensation, but in most circumstances, being able to show that there has been a breach will give that person a good prospect of success.
Okay, so potential double impact for the business. And who enforces the regulations? You mentioned criminal prosecution, so does that mean police are involved?
Well, they might be. They might come on site after an incident, but it's the health and safety executive, who is the government regulator responsible for ensuring that businesses comply with their health and safety obligations. The HSE might investigate after an incident too, but a lot of its work is proactive. It can inspect businesses and take action if it finds activities which create a risk of injury. And sometimes the HSE will tell you it's coming, and other times it'll arrive without any warning.
Okay, and how does the HSE decide whether to inspect a business?
There are different kinds of visits from the HSE. It can't inspect every business, and so it focuses its resources where it thinks there is the most risk. That might be in high risk industries, or it might be businesses who've been reported to the HSE by employees or members of the public. The HSE might also come back to a business where previous visits have thrown up examples of poor practice. And as we mentioned, it's also likely to inspect where there's been a major incident or injury.
Okay, and we know that the agriculture, forestry, and fishing sectors suffer a disproportionately high number of fatal accidents compared to any other industries. So I suppose we can anticipate that the HSE might be more likely to want to visit businesses within those sectors as they try to address that statistic.
Yeah.
So what happens when the HSE visits?
Well, that'll depend on why they're there. For a routine inspection, you could expect the HSE inspector to ask you questions about your business and the activities your business involves. They want to find out what your workers do and any machinery or equipment you use and chemicals that are involved. They'll also want to see paperwork, and they want to see evidence of risk assessment, planning, and safe systems of work. They might take photographs of what's going on. One thing they will want to do is to speak to your workers and ask them about what goes on. If the visit is in response to a particular incident, then the inquiries will be focused on that. But when the inspector's there, he or she will make further inquiries if they notice any other activity which seems to be breaching the regulations or creating a risk of injury. And I suppose that's a good point to reiterate that to be in breach of your health and safety the regulations, something doesn't have to have gone wrong. You can be prosecuted even if no one's been hurt or injured.
Okay. And then, so then if the inspector does find something that's creating a risk of injury, what is likely to happen then?
Well, broadly speaking, there are four kinds of things that can happen after an inspection. You could be issued with a notice of contravention. This is essentially a letter which tells you which health and safety laws you've broken and how you've broken them. It'll tell you what you need to do to stop breaking the law. There needs to be a material breach of the law to get one of these. Something very minimal won't prompt one. The important point about a notice of contravention is if you get one, you have to pay for the inspection. And getting one won't prevent the HSE from taking any further action against you, but it's likely to be an improvement notice rather than something more serious. So the HSE has two kinds of enforcement notice, and the first kind is an improvement notice. If you get one of those, you'll be told what you've done wrong, what needs to be done to fix it, and a timescale to achieve that. It's a criminal offence if you don't make the changes within the given timescale. The second kind of enforcement notice is a prohibition notice. This means you must stop the activity immediately. You'll be told what needs to be done to make the activity safe. And it's an offence not to comply with that notice or to start the activity again without making the changes. And the fourth option is prosecution, and that could be prosecution of the business or individuals within it. And that's where the HSE considers that the breach is so significant that they should proceed straight to criminal prosecution.
Okay, so then just going back to the enforcement notices, if a business gets one of those improvement or prohibition notices and does the work and complies, will that be the end of it?
Not quite. With enforcement notices, HSE publishes details of those on its website. They're searchable with the business name and the business sector, and the entry in the website includes details of the breach. The notice will appear on the website for 5 years. Obviously, that can have an impact on the reputation of your business and also the willingness of other businesses to work with you. It will, of course, be visible to your employees and also prospective employees.
Okay, yep. So consequences, obviously, of not meeting your health and safety obligations can be significant.
Yeah.
Taking that into account, one final question that a lot of people might be wondering, and that is, what is the current position? I mean, we know that farmers just now are appealing for people to come forward to help with harvesting fruit and veg. That could result in people working on the land who've no experience and possibly in large numbers. It might be quite a task to ensure those people are all trained and know how to avoid risks and act safely. That's going to be adding time and expense to businesses that are already under pressure. So, I mean, is there likely to be any leeway from the HSE if something goes wrong, or given current circumstances and the emergency measures in place?
I don't think so, is the answer to that. The HSE has confirmed that it continues its enforcement role during the pandemic, and it's emphasised that the duty to comply with health and safety requirements remains. There have been some accommodations made by the HSE recently in the news in relation to the reuse of single-use PPE in the healthcare sector, but there's no general relaxation of the obligations on businesses. At the moment, there probably is a limited capacity for criminal prosecutions, but those could take place at a later date. And in addition, there's always a possibility that the HSE attains and issues a prohibition notice stopping work immediately, and it might take some time before rectification can take place.
Okay, so something for those businesses to bear in mind, I guess. We're going to finish up there. Next time, we're going to be looking at how businesses can address their risks and comply with the legislation now that we've found out what can happen when they don't comply. In the meantime, if anyone listening would like further information on anything we've spoken about, then please do get in touch.